Hello everyone. The Landlord and Tenant Act 1988 is an important statute in the context of alienation in leases. It imposes a statutory duty on the landlord in receipt of a written application by the tenant for consent to assignments, underlettings and charges. And the statutory duty is to give consent to the application within a reasonable time, except where it is reasonable not to give consent, and it requires the landlord to serve on the tenant written notice of the landlord's decision within a reasonable time, specifying the conditions to which consent is given, or if consent is refused, the reasons for withholding it. For the tenant, therefore, the Act gives statutory relief which may be urgently given in the form of a court declaration that the landlord is unreasonably withholding consent, thus ratifying that all-important assignment or underletting and enabling the tenant's transaction to go ahead despite the obstinate or unresponsive landlord. For a landlord, the statutory duties I've just described make it important that a prompt and full assessment of the application is made once the written application is received from the tenant. So written applications for consent need to be treated by landlords urgently and seriously. Now, the Act only applies where the lease requires landlord's consent to the dealing and that consent is not to be unreasonably withheld. If the lease allows the landlord to withhold consent in its absolute discretion, then the landlord is not subject to the statutory duties of the Act. And the Act only applies to consent to alienation. It has nothing to do with applications for consent to tenants' alterations. Nothing in the Act prevents the landlord from asking the tenant for reasonable information, such as about the assignee's covenant strength, that will enable the landlord to come to a decision on the consent, so long as the landlord does that within a reasonable time. The recent case of MMI Properties and Shepherd emphasises the importance of landlords acting reasonably when considering applications for consent to assign. The lease in question was a wine bar in Wilmslow. The business struggled as a result of COVID-19 restrictions and rent arrears accrued. The tenant identified a new company to which it proposed assigning its lease. Through solicitors, an application was made to the landlord for consent to assign on the 20th of August 2021. In September, the landlord raised numerous unparticularised issues. The tenant solicitor repeatedly asked the landlord for clarification. The landlord's agent refused to give it, telling the solicitor that he should refer to previous correspondence. None of those exchanges were clear about the covenant strength information required by the landlord. The landlord then finally asked a number of questions about the financials of the assignee and demanded that the information requested be provided by 5 p.m. on the same day, or the application for consent would be ended. Now, the solicitor said he would obtain that information, but not on the same day. The correspondence became agitated, and on the 7th of September, the solicitor for the tenant wrote that if the landlord wasn't prepared to discuss the application, it should give his decision. So the landlord refused the application on the same day on the basis of the covenant strength of the proposed assignee. The landlord re-entered the property, changed the locks and re-let the property to a new tenant. Now, the High Court found the landlord had acted unreasonably in withholding its consent as it had made its decision too soon. If the landlord had waited and obtained the necessary financial information on the assignee, enabling it to make an informed decision, then it may have been acting reasonably where that additional information didn't improve the proposed assignee's covenant strength. It's really important for landlords to act reasonably when considering applications for consent to assign or underlet. If the landlord requires further information about the proposed assignee, it must specify what that information is that they require, which was not the situation in this case, where the tenant had got mere obfuscation. If the landlord fails to be clear about the information needed, a refusal of consent may be unreasonable, even if, had the information been specified and provided, a reasonable landlord would have refused their consent. And if the information is requested clearly, a landlord must allow the tenant a reasonable time for that information to be provided. If a landlord imposes arbitrary and ridiculous deadlines, as in this case, then their refusal is likely to be unreasonable, even though it may have been reasonable if they had waited for a proper period of time. So the Landlord and Tenant Act 1988, very, very important. The landlord needs to treat it very, very seriously whenever getting applications for consent. Thanks for watching today, and I'll see you all again in 2 weeks' time.